An exclusive for you on Alex Belfield. Not only is he now out of prison, having served 2.9 years in prison out of a 5.5-year sentence, which I thought was a little bit unusual given the circumstances, for reasons I'll explain in a moment, particularly when compared with other sentences, which I'll discuss in the second half of this video. But not only is he out of prison, I understand that he is also going to be back on YouTube. So many people might have understood that he would not be allowed to talk to you or do any kind of media once released from prison, which was something that I took an interest in, because when you are released from prison, you are on license for the remainder of that sentence period. So allow me to explain. So if, as in Alex's case, you have a 5.5-year sentence, you'll typically serve half in custody and the other half on license. Then you are given license conditions, which sometimes means you can't go to a certain place, or you're restricted to a certain place or a certain time, and you may be restricted from doing certain things. So many people might have expected that he would not be allowed to talk on YouTube or anything else of that nature. So I was very interested in this. So here's the exclusive for you. Both before you are sentenced and when you are released, there are certain reports that are done. Before you are sentenced, there's a pre-sentence report, and whilst you're in prison and when you're released, there's what we call an OASIS report, which determines the prospective level of risk that said person places on society. Now, I understand that the probation and pre-sentencing report did not recommend prison, despite the fact that Alex ended up with 5.5 years, some of which were consecutive, which again I'll explain in a minute. But not only was it not recommended for prison, he got 5.5 years and served 2.9 months. But also, the OASIS report by HMP said that he was a 0.17 risk to the public, according to that report, and therefore there was zero rehabilitation recommended, as those statistics were too low for any of those courses. Now, if you are a higher risk to society, which again is something that I'm going to focus on in the second half of this video, in my view, people that are a severe risk to society and deserve lengthy sentences, but again, I'll come back to that in a minute. If they do qualify for these courses, they get rehabilitation, they get stronger curfews, and all of these sort of things. But as I say, from what I understand, it was a 0.1% risk to the public and zero rehabilitation recommended, as those statistics were too low. Now, very briefly on Alex's sentences running consecutively as opposed to concurrently, meaning they ran one after another, which is why it was a much longer sentence of 5.5 years. This, to put it simply, is the way that the court punishes an offender, more so when they think the offending was more serious. Very often, in fact, more usually, offences that occur at or around the same time, or they are linked, etc., would run concurrently. But again, I've talked about that more in other videos when I was reporting on it contemporaneously at the time. And thus, I now understand that Alex Belfield is able to return to YouTube, which I see from his X profile here, that he will be live again at 6 p.m. this evening, the 22nd of June. So I was also curious as to how many people supported Alex Belfield, because obviously being a relatively high-profile case, it was taken very seriously by the court system, but obviously Alex did receive a lot of support from the public, and Alex sent me this of the mail that he received whilst he was in prison. Just a staggering amount of mail, which just goes to show how many people can still support somebody even when they are prosecuted, convicted, and go to prison. Just like Lucy Connolly, which I'll come on to now, because I'm going to contrast and compare Lucy Connolly's sentence, who got 2 years and 7 months in prison, given that it was a single tweet, which everybody accepts that she shouldn't have sent, but did nothing else apart from send that one tweet. Now, I maintain that she probably should have pleaded not guilty, and that she may well have been found not guilty had she taken that to trial. But it was reported that people were either put under or at least felt under pressure to plead guilty on the threat that they might be remanded into custody until the trial, which might be a year or more in any event. But such as it is, Lucy Connolly received 2 years and 7 months in prison. Now I'm going to compare and contrast that with this case here, because 2 delivery drivers were sent to prison for assaulting a teenage girl whilst delivering something, and they did so in her own home. This is an utterly grotesque situation. So these two men were delivering a television unit to this girl's house while her mum was at work. The mum had bought this on eBay. The 14-year-old girl answered the door, the mum was at work, the two men carried the unit upstairs where one of them pinned her against the wall and sexually assaulted her while the other one was laughing, and then the other one proceeded to sexually assault her as well. The girl then locked the front door, immediately phoned her mum, crying hysterically, told her what happened. Both men were arrested that morning in Preston, and both have been sentenced to a prison term of, wait for it, 2.5 years. So less than Lucy Connolly, even though as much as we agree that Lucy Connolly should not have posted that tweet, that's all she did. Albeit it was an offence of inciting violence and she pleaded guilty to it. That aside, she didn't physically go anywhere or physically do anything. Whereas in contrast, these two men physically went into this girl's own home and both assaulted her, and they got a lower sentence than Lucy Connolly. So we, I think, do have to ask ourselves whether this whole system needs a reform. Because I think as a society, we would look at these sentences and possibly collectively come up with a very different sentence for these two men. Let me know in the comments what you think about that. Because personally, personal opinion alert, I don't do many of them on this channel. Subscribe to my Off the Record channel if you want my real personal opinions, but a rare personal opinion on this channel here. Personally, I don't think this is right. I think the sentence for these two guys here is not enough. Albeit, I caveat, I'm not blaming the judge here. Many people will. It's too easy to blame the judge. But the judge is following the sentencing guidelines, which, even without bringing them up on screen and checking, judges have to follow those sentencing guidelines. And if it's outside of those guidelines, it can be appealed. And then the Court of Appeal will likely allow the appeal because it's not in line with the sentencing guidelines. So these guidelines end up with sentences like this, which I personally think is not enough for these two men to go into this girl's home and personally assault her, sexually assault her in her own home. I think that's wrong, personally, but I just thought that was an interesting contrast because whilst talking about Alex Belfield coming out of prison and still clearly has overwhelming support from the public, albeit I'm not detracting from what has happened and the people that have complained about what happened in that story, which I reported in previous videos, you can find those below, I do find that somewhat interesting. But as I say, my exclusive for you is that he has been told that he can return to YouTube, he can continue to talk and maintain his right to the freedom of expression. Obviously within the bounds of the law, and that would entail not contacting any of the victims of those offences and staying within the bounds of the law going forward. Obviously any breach of those things or further offences whilst unlicensed would not be a good idea. But one thing I do want to clarify is that I have seen 2 of these offences reported as simple stalking. Now, that isn't referenced in the Act. It's just referenced as the offence of stalking in Section 2A in the Protection from Harassment Act 1997. The other 2 offences were under Section 4A, which is stalking involving what the judge referred to as causing serious alarm or distress. So I hope you find that interesting, but do let me know in the comments what you think about the disparity in sentences here, i.e. between Lucy Connolly and these 2 guys that have been convicted of this horrendous assault of this girl in her own home. I accept that they are very different offences, they are very different guidelines, but my point is, I think as a society, we should be looking at these things in a system of open justice and we should be considering them together. And whether as a society, we think one is more serious than the other. But let me know what you think in the comments section below. As I've said previously, I am not a judge and I didn't write these sentencing guidelines, but let me know what you think. Thank you for watching and I'll see you next time.